Cruel and unusual punishment. It's prohibited under the 8th Amendment of the United States Constitution. Well, what's cruel and unusual punishment? Hey, you know, when the Founding Fathers put together the Constitution, they had seen Great Britain engage in punishment that consisted of some pretty heinous things, which we've sometimes seen depicted in movies, including disembowelment and all kinds of horrid stuff. Well, they said we can't have cruel and unusual punishment. But how about people under 18 years of age? Does punishment that is meted out to people who are under 18 years of age, is that viewed a little differently than punishment that goes to an adult? Well, that takes us to this week's case. Involves a real case. Young man, 16 years old, living in California. He was a member of a gang. Well, at one point in time, he assaulted a rival gang, shot a gun into a group of guys, wounded one of them badly. He was arrested, he was tried, and he was sentenced to 110 years in prison before he'd be eligible for parole. His attorney argued on his behalf that that was cruel and unusual punishment. I mean, the Constitution is designed to basically set the relationship between government and people. And in this instance, it says government can't engage in cruel and unusual punishment. And by having a kid who is put into prison for 110 years before he is eligible for parole is cruel and unusual because, it was argued, he wouldn't have an opportunity to mature, he wouldn't have an opportunity to live his life and possibly repent, possibly become reformed, possibly be able to lead a productive life. On the other side of the coin, the prosecutor argued that, well, wait a second, 110 years is not cruel and unusual punishment because after 110 years, he would become eligible for parole. Therefore, he isn't sentenced to life in prison without the possibility of parole. Well, this went up to the California Supreme Court. California Supreme Court heard both arguments, said to the prosecutor, hey, you know what? 110 years before possibility of parole for a 16-year-old young man, that is essentially life in prison without the possibility of parole. Therefore, we find it cruel and unusual punishment. Okay, so what do we learn from this case? What do we learn from this case? Very simple thing. Again, Constitution is designed essentially to protect people from government. There are various prohibitions that exist that prevent government from doing certain things. Unreasonable searches and seizures, cruel and unusual punishment. But the standard varies from young people to adults. In this instance, the 16-year-old was found to be subjected to cruel and unusual punishment. If he had been 26 years old, would that sentence have stuck? Probably. Probably would have, because he would have been over 18 years of age. So, what do we learn? Well, there is a different standard in applying the constitutional standards to people who are under 18 and to people who are over 18. And a big part of that really is simply human nature and recognizing that people change as they age, as they mature. Now, Constitution doesn't say anything about it applying differently to people under 18 and people over 18, and that's how case law develops, or cases one at a time that determine how, in fact, these constitutional guarantees will be applied. Okay, bringing these cases, as we bring you cases every week, so you understand how the law works. I'm David Allen.